Hello, my name is Jonathan Henderson, and today I'll be presenting on the Supreme Court case McGowan versus Maryland. So let's start with a brief overview of the case McGowan versus Maryland. So this was a significant case from 1961 that delves into the intersection of state regulations, specifically Sunday closing laws, and religious freedom under the First Amendment. This case, officially cited as 366 US 420, explores challenges to Maryland's Sunday blue laws. The case questions their impact on the establishment and free exercise clauses. The appellants contended that these laws, applied to the states through the 14th Amendment, infringed upon religious liberty. The parties involved and basic facts. So, who are the parties involved? In this case, the appellants were 7 employees of a large discount department store located in Anne Arundel County, Maryland. They were challenging the constitutionality of Maryland's Sunday closing law after being convicted and fined for selling merchandise on a Sunday. The appellee was the state of Maryland, which defended the legality and constitutionality of the Sunday closing law, Maryland Annotated Code, Article 27, Section 521. So fundamentally, this case was about these employees challenging a state law that restricted Sunday business operations. So, setting the scene and the basic facts. Let's look at the basic facts. The 7 appellants were employees of a large department store. They were indicted and convicted for the Sunday sale of several items: a 3-ring loose leaf binder, a can of floor wax, a stapler and staples, and a toy submarine. This directly violated Maryland's Sunday closing law, specifically Article 27, Section 521. This law generally prohibited the sale of most merchandise on Sundays statewide, though it contained exceptions for items like tobacco, confectionaries, milk, bread, gasoline, medicines, and newspapers. Legal issues and religious freedom. Now, let's look at the law in question, Maryland's Sunday blue laws. The specific law was Maryland's Sunday closing statute, Article 27, Section 521. While it generally banned Sunday sales statewide, there were initial exceptions. The situation was further complicated by recent amendments specific to Anne Arundel County, where the appellants worked. These amendments expanded exceptions to include all foodstuffs, auto and boating accessories, flowers, toilet goods, hospital supplies, and souvenirs. Notably, an Anne Arundel County amendment also exempted retail establishments with no more than 1 employee besides the owner. Beyond this sales prohibition, Maryland had other laws limiting various Sunday activities, often varying by county. The appellants argued these statutes were unconstitutional under the 14th Amendment, including claims related to religious freedom. The core of this case, for our purposes, revolves around religious freedom, as protected by the First Amendment and applied to states through the 14th Amendment. The appellants raised 2 primary arguments. First, they contended that the Maryland Sunday closing laws violated the Free Exercise Clause, arguing the statute's effect was to prohibit the free exercise of religion. Second, they argued these laws violated the Establishment Clause, claiming the statutes were laws respecting an establishment of religion. The first legal issue we will look at is focused on the Establishment Clause. The appellants argued that these laws were, in effect, respecting an establishment of religion. They pointed out that Sunday is the Sabbath for the predominant Christian sects. Their assertion was that the purpose of enforcing a stoppage of labor on Sunday was to facilitate and encourage church attendance, induce individuals with no or marginal religious beliefs to join Christian sects, and to create a tranquil atmosphere intended to aid church services and the religious observance of the day. The second legal issue we will look at focuses on the Free Exercise Clause. The appellants argued that the statute's effect was to prohibit the free exercise of religion. However, the Supreme Court held that these appellants had no standing to raise this particular contention. The court's reasoning was that the appellants only alleged economic injury to themselves. Crucially, they did not allege any infringement of their own personal religious freedoms due to the Sunday closing. The record was entirely silent as to what their religious beliefs even were. Therefore, because the litigant may generally only assert their own constitutional rights, the court concluded they couldn't make this specific argument. The Supreme Court's decision. So, what was the Supreme Court's decision? The Supreme Court affirmed the Maryland Court of Appeals decision, upholding the Sunday closing law. But there was a variance between the rulings for the standing and merits of the Establishment Clause claims. First, regarding the Establishment Clause standing, the court found the appellants did have the legal right to complain that the statutes were laws respecting an establishment of religion. This was because they had suffered direct economic injury, which they alleged was due to the imposition on them of Christian religious tenets. However, on the merits of the Establishment Clause claim, the court ultimately held that Article 27, Section 521 of the Maryland Code is not a law respecting an establishment of religion, affirming the lower court's decision. The court acknowledged the historical religious motivations of Sunday laws, but emphasized their evolution towards secular considerations. It concluded that, as currently written and administered, these laws are primarily secular, bearing no unconstitutional relationship to an establishment of religion. The Maryland State Supreme Court had determined the law's present purpose was not to aid religion, but to set aside a day of rest and recreation, a finding the U.S. Supreme Court accepted. The court stated the law's purpose is to provide a uniform day of rest for all citizens, and the fact that this day is Sunday doesn't bar the state from achieving secular goals. Why I agree and conclusion. Why I agree. Evolving purpose of the law. So, having reviewed the court's decision, particularly on the Establishment Clause, I agree with the Supreme Court's decision in McGowan versus Maryland that the law did not violate the Establishment Clause. My primary reason is the court's correct focus on the evolution of these blue laws. While undeniably originating from religious motivations, the court found that their emphasis shifted over centuries towards secular societal goals. By the time of this case, the court accepted the Maryland Supreme Court's determination that the statute's present purpose was not to aid religion, but to set aside a day of uniform rest and recreation for its citizens, fostering family activities, community engagement, and a general break from the work week. Why I agree, secular goals and practicality. Another reason I agree is that I believe the law's primary effect was secular. The court rightly acknowledged that selecting Sunday doesn't automatically make the law an unconstitutional establishment of religion, even if it aligns with the tenets of a religion. Many laws, like those against murder or theft, align with religious principles but are valid due to their secular public welfare purpose. Here, the primary effect was providing a uniform day off, promoting well-being and recreation. The numerous exemptions in Maryland's law for things like foodstuffs, auto accessories, amusement parks, and even small shops further demonstrate an intent geared towards recreation and convenience, not strict religious observance. Furthermore, the state has a legitimate interest in promoting general welfare through a common day of rest. This allows for shared leisure time, benefiting society more effectively than staggered individual days off. Sunday has become a widely recognized day for rest and family in the U.S., irrespective of religious beliefs, making its choice by the state a practical one reflecting societal norms rather than an endorsement of religion. Why I agree, no coercion, distinguishing precedent. Ultimately, I also believe that there was no coercion or direct aid to religion. The Sunday closing law didn't compel church attendance or the profession of any belief, nor did it involve using tax money to support religious institutions. It simply regulated secular commercial activity. The court correctly distinguished this case from instances like McGowan versus Board of Education, which involved direct state participation in religious instruction in public schools and the use of tax supported facilities for religious purposes. In conclusion, the Supreme Court's decision in the McGowan case underscores the fact that laws can evolve and a state can pursue legitimate secular goals, like a uniform day of rest, even if that day historically had religious significance. The focus was correctly on the statute's present secular purpose and effect. So let's briefly recap. In McGowan versus Maryland, the Supreme Court upheld Maryland's Sunday closing law against the challenge that it violated the Establishment Clause. The court reasoned that despite the religious origins of such laws, their primary current purpose had evolved to become secular, specifically to provide a uniform day of rest and recreation for all citizens. The court also found that the appellants lacked standing to bring a free exercise claim because they did not allege an infringement of their own religious freedoms. I agree with this ruling, as the court effectively balanced the state's legitimate secular interests with the protections of the First Amendment. Thank you for your time, and God bless you.